Hello, everyone. Welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video, we will be covering an overview of employment discrimination using Chapter 3 of our textbook. We'll be looking at whether or not employment discrimination has been curtailed or not in the workplace, what we mean by that term, what the different types are. I think the reality is that things have gotten better since the Civil Rights Act of 1964 was passed, but we still have discrimination occurring on illegal bases in the workplace. The discrimination can be very subtle, it can be mixed. We have, I think, a glass ceiling, sometimes referred to that way as the invisible barrier that can exist, for example, for a woman seeking to get to the upper echelons of her workplace. We have a number of laws that have been passed in the last 50 years for the most part that are designed to prevent employers from making decisions on the basis of categories that Congress or the other legislature has decided shouldn't be the basis. You can see a list of them here. Here's a definition of employment discrimination. The best way, I think, to think about it is that an adverse employment action has been taken against someone who is in some sort of a protected class. Sometimes there might be a dispute over whether an action really was adverse. Take a look at the example on page 70 of your textbook, in which someone was supposedly given a lateral transfer after she informed her employer that she was pregnant, but in reality, the new position was less desirable. When it comes to the specific categories that are illegal to base an employment decision on, race and color are covered in Title VII of the Civil Rights Act of 1964. Note that race and color do not mean the same thing. Sex is also covered in the Civil Rights Act of 1964, as is national origin. National origin is also covered in the Immigration Reform and Control Act, which people sometimes think is designed just to regulate the number of foreign workers coming into the country. It actually also protects people against discrimination on their national origin. Religion is protected under Title VII as well. The Immigration Reform Act protects us if we do not happen to have U.S. citizenship. Age and disability, as we will see repeatedly throughout this course, are also illegal ways to make a decision in the employment context. Pregnancy is to a certain extent protected. We'll be talking about the Pregnancy Discrimination Act, which does not go as far as some of you might think. Your military service can protect you against discrimination, as can your genetic information. Unlike some other areas of employment law, local governments, including cities, are free to prohibit discrimination based on factors that are not prohibited in the federal law, such as gender identity. Here is the mayor of New York City within the last couple of years passing or signing into law a municipal ordinance in New York City that prohibits discrimination against someone based on gender identity. There are four types of discrimination that we'll be looking at: disparate treatment, disparate impact, a failure to accommodate, and retaliation. We will be seeing these throughout the course because all of these types of discrimination can come up at all phases of the employment relationship, from hiring, promotion, and termination, and everything in between. Here's some very practical advice. Figure out what the protected classes are and be very sensitive to those. Always try to be fair. If someone in a protected class seeks some sort of accommodation, listen and be fair. And really, if someone complains or files charges, be careful that you are not viewed as retaliating against that person. Let's start with disparate treatment cases. Uh, Clearly, if you have a written or even an unwritten policy that says we are going to treat a protected class differently than non-protected classes, such as Southwest Airlines saying we are only going to hire female flight attendants 40 years ago. Look at the textbook, page 75. That would be illegal disparate treatment. It is possible for someone who has a policy that goes against a protected class to argue as a defense that the distinction being made is a bona fide occupational qualification. We'll be talking about that. Sometimes people refer to reverse discrimination cases. It's actually a misnomer that generally applies whenever a white male believes that only women are being hired, or perhaps a Caucasian believes that only a person of color is being hired. The concept of pretext is very important. We'll be talking about that throughout the course as well. Here's an example of what we mean by pretext. Take a look at this case, Jones versus Oklahoma City Public Schools. It's a fancy word for uh, an excuse that doesn't work. Many times in a disparate treatment case, the employer will say, well, actually, I had another motive for taking whatever the adverse impact was, making the decision that I made. And the other one was legal, and the other one, the legal motive should control. Those are sometimes called mixed motive cases. They are difficult when they arise. If you are complaining about age discrimination, however, it is easier for your employer to use a mixed motive uh, argument than would be the case otherwise. There are other forms of disparate treatment discrimination, including harassment. We will be looking at harassment periodically through out this course. Harassment is a treatment of another person, and it is illegal in many cases, particularly if it is based on gender. If you believe that you are being treated differently because of your protected class, there are some steps that you must go through, including the pleading of what's called a prima facie case. That is, arguing just enough for you to shift the burden over to someone else. You have to prove that you are in the protected class, that the employer knew you were in the protected class. Take a look at page 79. If you're not yet visibly pregnant when your employer takes what you think is an adverse employment action, treats you differently because you think you are pregnant, the employer might be able to successfully say that it is not liable. You have to have applied for the opportunity, you have to be qualified for it, and you have to have been turned down. If you are able to prove those things, then the burden shifts over to the employer, and the employer will try to produce as much evidence of a lawful motive as it can. If the defendant is able to produce that evidence, then the process shifts back to you, and you can try to argue that the employer really didn't have the motive that it's arguing, and you can try to prove that with evidence. The evidence can be direct, some piece of paper that clearly says, let's not hire people in this protected class. More often, though, it's going to be circumstantial evidence, things that don't constitute a smoking gun but still can prove it. There will be a simulation on this topic. You will see in Chapter 3, Question 2, the question of whether the 56-year-old scheduler who lost out on his job to a 40-year-old could successfully meet the disparate treatment argument based on age that he was trying to make. Here's some circumstantial evidence that went against Ohio State University when this these two women filed an age discrimination case, and the files of the department chair uh, showed statements like this being made by the department chair. I think that's pretty good circumstantial evidence that he was discriminating on the basis of age. In disparate treatment cases, we oftentimes have a low-level supervisor with discriminatory intent, but upper management doesn't have that discriminatory intent. You get into what's called the cat's paw theory. Cat's paw meaning that you can see the uh, evidence of the wrongdoing, the cat's paw print throughout the company, even if it's not shared at the top of the company. There's a simulation on this as well. Take a look at this case in the textbook about the bias of an HR manager against African Americans that was attributed to upper management. Here is the simulation question that a pair of you will be getting. The 62-year-old HR assistant who clearly did wrong in disclosing confidential medical information, but was her immediate supervisor really motivated by that, or by the fact that the HR assistant was an older worker? The cat's paw theory came into play in that case as well. Moving on to the second form of illegal discrimination, uh, adverse impact. This is where an employer might not have an illegal intent, but the effect of the employer's actions in hiring or promoting or terminating employees, whatever it might be, might have an adverse effect on people in a protected class. An example of adverse impact might be a requirement for a high school diploma. That's a neutral requirement, doesn't necessarily, um, it's not aimed at African Americans. However, in Griggs versus Duke Power Company, a Supreme Court case that came about shortly after the Civil Rights Act of 1964, the Supreme Court said that even though it was a neutral requirement, a high school diploma requirement had an adverse impact on African Americans, and therefore could not be used as a hiring tool at Duke Power Company. Again, as is the case in adverse treatment cases, in an adverse impact claim, if a plaintiff proves his or her prima facie case, the burden then shifts to the defendant. And in an adverse impact case, the employer then has to prove that the challenged requirement for the job is in fact job related and consistent with business necessity. Slightly different rule for age discrimination cases. The way to remember the different rules for age discrimination cases is that the age discrimination law is much more pro-employer and less favorable for employees. Sometimes a combination of factors can come together to create an adverse impact for people in a protected class. Here are some things that have come together in different situations: employment tests, height and weight requirements, language requirements, physical strength tests. We will be looking at these as we go about the life cycle of an employment relationship in future classes. If the plaintiff is able to prove his or her prima facie case, the employer then has to show that the requirement in question is job related and consistent with business necessity. The age cases are handled differently. In the case of age, the employer simply has to show that the employment action was taken for any reasonable factor other than age. Another category of employment discrimination that is illegal is retaliation of some sort. It may not be that there was actually any discrimination based on someone's protected class, but it is illegal for someone to even uh, uh, suggest it and then be retaliated against. There are two sorts of protected activity here. One is participating in the enforcement of a law, complaining about discrimination, for example. Another way to get protection from anti-retaliation laws is to speak out against discrimination generally, even if you don't think it has been applied to you. In a retaliation claim, again, the plaintiff has to prove a prima facie case that he or she uh, engaged in some sort of protected activity, suffered a materially adverse employment action that were related, and that there was some uh, temporal proximity, a fancy word for complain on time. Take a look at the textbook page 99 when there was a year's gap between the time that someone felt that he had been retaliated against and the lawsuit alleging that. If the employer is able to say that there was a basis for what it did, the plaintiff still has a chance to prove his case by providing some evidence that would cause us to not believe the employer. Take a look at the case in the textbook Galita versus Gray, where the employer said that he was transferred to a different job in the Department of Health in retaliation for his agreeing with someone else who had complained about racial discrimination. That's it for this set of slides. In our next set of slides, we'll start the actual life cycle of an employment relationship, starting with recruitment of new employees.